can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge.
Please.
The nature of this case is a racing on a highway case, so I just want to let you know that these dim summaries will be separate for each defendant because they were stopped at different locations, if that makes sense. Okay. On April 17th, 2025, in Harris County, Texas, an officer was on routine patrol when he observed a Silverado pickup truck and a Cadillac motor vehicle accelerate at a high rate of speed side by side in an attempt to outdistance one another. The officer observed a third vehicle, a Dodge Charger, increasing speed while following the other two motor vehicles. The officer accelerated approximately to 108 miles per hour in an attempt to catch up with the three vehicles. The officer noted the posted speed limit on the roadway was 65 miles per hour. The officer notes that he was traveling at 101 miles per hour, maintaining view of the vehicles and recording the incident with his dash camera. The Cadillac and the Silverado truck exited the freeway, and the officer got right behind the pickup truck and paced it, traveling 85 miles per hour. A traffic stop was conducted on the Silverado, and the defendant admitted to the officer he was racing with the other individuals. While speaking with the defendant...
We're talking about Brown, right?
Yes, Your Honor.
Okay.
And while speaking with the defendant, the other two vehicles arrived on scene and admitted to the officer that they were racing along with the defendant. I guess that covers that.
Who came and admitted?
It said the other two defendants.
The other two came in.
Yes, Your Honor, that's what it states. I'd be happy to read the other.
I'm going to find that there's sufficient probable cause to go forward with your cases, gentlemen. Let me tell you now that the state of Texas and the wisdom of our legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from those who are arrested for racing. I have had cases in here where they have seized and taken a car from someone who was caught multiple times participating in this type of behavior. Don't do it. Do you understand?
Yes, sir.
If I find that you do, the first thing I will do is I will put you in jail, and then I'm going to take your ability to drive away from you while this case is open. Living in a city as big as Houston without the ability to drive blows. Do you understand?
Yes, sir.
Each of you, none of you participate racing, street takeovers, donuts, reckless driving maniacally, or putting others' lives in danger. Do you understand? If I find that you're driving at 100 or something like that, it's just not going to go well for you guys. So do you mind filing conditions on each of, no racing, reckless driving, takeovers, anything of this nature, please?
Yes, sir.
And then also, let's go through each one to see if they have valid licenses.
Yes, Your Honor. For defendant Thomas, we do have an eligible license.
Okay. Also, each of you're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must have car insurance. If you don't have either, you are not allowed to drive.
For defendant Brown, we do have an eligible license as well.
Okay.
And then for defendant Graves, the license is eligible.
All right. Gentlemen, do you have the ability to hire a lawyer, Mr. Brown? Okay. Do you have the ability to hire a lawyer?
Yeah.
Okay, we're going to give you time to go hire a lawyer. We're going to give you 30 days. When you come back, please have a lawyer. I'm going to have you each go to Victoria, sign a reset. Then we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. We have enough death on our streets. Don't contribute to it. You understand?
Sure.
All right, come on, guys.
Right out of the gate, this judge is sending a message. Street racing in Texas is not treated like some harmless late-night flex. Once the words 108 miles per hour hit the courtroom, this stopped being about speeding tickets and started sounding like a public safety threat. And here's the wild part. The defendants allegedly drove back to the traffic stop and admitted they were racing. That's the kind of statement defense attorneys hear and immediately start rubbing their temples.
Failure to ID, I'll pull up now.
She actually has this pen.
She has five statements. I was trying to hold on as judge.
Take your time, Blaze. There's never a problem. Can you read to me what happened on the failure to ID?
April 22nd, 2025, officer dispatch in reference to a in reference to an earlier motor vehicle. Complainant stated that at 4:30 a.m. she heard a car alarm go off and looked out the window and saw two individuals leaving.
Oh my God, you're telling me this is a BMV?
No, it's not being here.
That's the co-defendant,
It's
Judge.
co-defendants.
She's with. This is a party.
Not charged though, you're not going to say that, but complainant approached the suspect and defendant Silva stated that she was, quote, going to beat her ass if she kept following me. The complainant was able to flag down an officer and the defendants. The other complaining witness, the owner of the vehicle, said that the officers, there was a red paint on the front seat of the complainant's motor vehicle. Complainant observed that a bike that defendant Silva was riding on had red paint on the seat, and the back of defendant Silva's pants was also red paint. During the investigation, I observed defendant Silva with red paint on the back of her pants. During the investigation, defendant Silva admitted to going to the vehicle to find things changed. Once the defendants were detained, officers asked what the defendant's name and date of birth was. She first stated that her name was Sierra Johnson, date of birth 4/18/2002. Officers asked for a clarification on the spelling. Officers then asked if she ever had a Texas driver's license or ID. She stated she did not. Officers ran the given name, but nothing came back. Officers then called for Mogan Davis. While officers were waiting, he asked the defendant what her name was, and she said that her name was spelled Sierra, Ceirra, with a C instead of an S, and that Johnson was her mom's last name, and that her real name was Torrance. Officers ran the new name and Texas driver's license, came back to defendant Torrance with multiple City of Houston Precinct 2 warrants.
So the co-defendant got charged.
The defendant was charged, Your Honor. I'll pull it up now.
Why not Miss Torrance?
I'm going to read in here, Judge. I don't want to speculate, but I think all of the evidence can point to the co-defendant. And in fact, the co-defendant admitting to going into the vehicle.
There was red paint in the car.
Right.
She has red paint on her.
That was,
No, that was the co-defendant. I don't.
Was she acting as a lookout?
I don't know why you did not take a B&B on this. I don't want to speculate. All I can see is that obviously there was a decision made and take that they didn't have enough for B&B, but they had.
Anna, as much as I love you and as much as I appreciate.
This is one of those moments where the judge shifts from legal mode into straight-up life lecture mode. Losing your license in Houston? That's practically a side quest on nightmare difficulty. But underneath the humor, there's a serious warning here. Judges see these reckless driving cases as potential future homicide cases. The court is trying to stop tragedy before it becomes tomorrow's headline.
Your tenacity. No. There's something going on that's a lot deeper with this, and I'd like to find out. And what I'd like to do is have her T-rest, essentially. But I don't know what we need to do to get through to you, Miss Torrance, but apparently of all the stuff that we've dealt with now, in your case is what? $241 days, and yet we
Judge, if I may, this is a DWI. We got the alcohol report back and they sent it off to get tested for tox. We still do not have that toxicology report. And when we were...
I get it.
Okay.
I'm not saying...
It's just, she's not the one dragging it out. It's been waiting on the test.
You are on
Yeah.
law. You've now picked up a new case. I've repeatedly asked you to behave yourself while on bond. That you are not charged with 2 cases and you merely have the 1. I'm now revoking your bond number, DWI, and I'm taking you in. And what I'd like to do is have her T-Raz immediately to see how we go forward, because this is, in my opinion, throwing her to the wolves because something is going on, and I'm going to try to nip it before it becomes felonious.
Judge, we do have an alternative offer on there. That would include the TRS.
Yeah, I want to do it first,
Absolutely.
so we see how to go forward, because I don't want, I just,
And while we're here, actually, let me talk to the state about this before we, I'm gonna give them a heads up.
right. Mr. Bada, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement that they're offering you 3 days in jail with credit for the 1 day that you have done. You are giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It will be there forever. From now on, you are facing a minimum of 30 days in jail. You pick up any more DWIs. And I'm going to tell you, because it's going on your record, you get pulled over and you have anything funky to smell, whether it's weed, whether it's alcohol, what do you think is going to happen? Right. If you want to get lit, if you want to smoke until your heart's content, don't get into a car. I know that he has done above and beyond the call of duty in representing you without probably taking it. For all the money that you have saved, $50 will get you a ride to wherever you want to go in this life. Do you understand?
Did you catch that? The judge basically says, something deeper is going on here. That's a huge statement. Courts usually stick to the charge in front of them, but when someone keeps picking up new cases while already out on bond, judges start looking at patterns instead of isolated incidents. And once a judge thinks behavior is escalating, bond revocations come fast. Question for you guys. Do you think the court is trying to help her here, or already losing patience?
I don't know if I'm going to waive the supervisory fee with him. I don't know if he's truly indigent or not by OG. I know that you are, but I don't know. You know, I know that you've been throwing everyone for a loop the entire time, and so I want you to fill out an application form so I know that you are truly indigent. You're going to swear to this document. This is a public, not a public, but this is a governmental document that you're going to swear to. I want to know about your financial situation. I want to know everything about you. How much money you have at the bank, how much money you have coming in, how many cars you have, and then we'll take a look to see whether you're truly indigent. Do you understand? I'm going to suspend your license for 180 days. Do not drive until you get a license. So we will have you fill out an affidavit and I'll see whether you are indigent, and then we'll take a look. But really, this dude is really gone above and beyond the call to represent you for all the issues that you've had. So thank you so much for doing what you're doing. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement. Deputy, do you mind giving an application so we can work to see? Okay.
And Ron, do you need me to approach with?
No, I'll look at the document. If he does, then I'm going to waive it. If you do not qualify, you will be required to pay the supervisory fees. In this case, that is $3,000 plus court costs. Actions have consequences. You had the opportunity. When you pick up a DWI, you're going to pay for it one way or the other. You know, now this, with the conviction, it's going to follow you forever. All I hope is that 20 years, 30 years from now, this was enough of a hassle in your life that you, man, I had 3 beers. I better not get into a car. Time heals all wounds, but the law never forgets. Good luck to you. And
Thank you, Your Honor.
Bye. Okay, you ready? Come on up, sir. How are you? So, Mr. Randall, you're charged with failure to identify oneself as a fugitive from justice. That is a Class A misdemeanor. That was from 2022. And I guess you didn't show up for the arraignment, I'm assuming, so we revoked the bond. We issued the warrant. 3 years later, now you've picked up an assault bodily injury. On that one, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I don't know what happened in the assault, so we're going to find out. Okay, what happened?
Judge, before we get started, there is some use of profanity that's pertinent. How do you start it?
Dude, we don't have virginal ears. You can do whatever you want. Say it.
On April 22nd, 2025, in Harris County, Texas, a law enforcement officer was dispatched to an assault in progress.
That line goes hard. The law never forgets. And legally speaking, the judge isn't exaggerating. A DWI conviction can follow someone for decades, jobs, insurance, future arrests, even sentencing enhancements later on. This judge has a very direct style, but you can tell he's trying to hammer home one point. One bad decision behind the wheel can rewrite your future permanently.
Call and made contact with the complaining witness. The law enforcement officer observed the complaining witness to have blood on their face and fresh cuts on his face and near his eye. The complaining witness stated he walked on a bridge and passed the defendant and told him to have a good day. The defendant then stated, "What the fuck did you just say to me? You got a problem." The complaining witness told the defendant that he didn't have a problem and did not want any trouble. The defendant then got into a fighting stance and struck the complaining witness in the face multiple times, took him to the ground, continued striking him, and stuck his finger in the complaining witness's eye. The complaining witness stated he was in fear for his life. A witness corroborated the complaining witness's story.
Any damage to the eye?
Law enforcement officers took pictures of what he recognized to be a bite mark on the complaining witness. I will look for further damage evidence. The officer observed the complainant's eye being red and the bottom part of his eye having a fresh cut and abrasions on both sides of his face and above his forehead.
Okay, Mr. Randall, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. I don't know if you're going to bond out, but if you do, I'm going to put a monitor on your ankle because you're a flight risk.
I'm not gonna go anywhere. I mean, the assault
But
charge.
don't talk about it, really. You have the right to remain silent, exercise the right. That's why you have a lawyer, because whatever you say now, they're going to sit there, type it to try to use it against you. Just best not. So the problem is that I can't give you a PR bond. We gave you a PR bond last time and you took off. Now, 3 years later, you picked up a new case. And the only reason we have you back is because of this. So I can't just give you another PR bond, you know?
And Your Honor, Mr. Randall would like me to communicate to the court that he was under the impression that his prior offense was dismissed and it was a misunderstanding, but that he has every intention to satisfy his obligations.
I get it. I understand. Where do you live?
I believe he's kind of in transient at the moment, Your Honor.
And that's a problem because I don't want to just give you another PR bond and you're going to end up on the street. You know,
It's hard to get lodgings here.
Allegedly here, they're just wishing you to have a good day. Have a good day. And now, you know.
And Your Honor, we have provided him with resources in order to try to find lodging and the like. So I think you said you were going to take advantage of that information that I gave you.
Yeah, I'm sorry, I can't. You know, you scare me. You know, you take off. And the only reason we have you back now is because
Sir.
of have a nice day.
No, I didn't take off. I've been right here in the city of Houston. It wasn't a flight risk or me ignoring the conditions of the PR bond. I showed up to the court. Like I said, the discrepancy said just with the criminal justice system up to this point is paramount to pretty much everything.
Who do you have in your life? Where's mom?
Lord.
Where's dad?
This exchange is a courtroom chess match. The defense is trying to frame the missed court date as a misunderstanding, but the judge keeps circling back to one issue: trust. Bond is basically the court saying, "We trust you'll come back." Once someone disappears for years and catches a new charge, that trust evaporates instantly. And honestly, the phrase "have a good day" turning into an assault allegation this violent? That's exactly why the judge sounds so alarmed.
Where's brother, sister? Who do you have in
I'm
your
here.
life?
I'm on my own. I actually came here to Texas to take care of VA and Social Security disability, to acquire a resource to just take care of that simple business and go back to Germany. That was it.
Germany, he said, Your Honor.
But I'm not a recluse or a loose cannon. How they trying to paint? It's wrong. That guy.
Don't talk about the past.
So if you had somewhere to go, like family members that are willing to take you in, I would consider it. But just to go back on the street. My fear is that we let you out and then the same thing happens again, where you just go out and then we just don't see you again, you know? So I don't know if you can somehow try to reach through some family or anyone that he may have, talk with them, and then I guess we'll go from there. Okay? All right. Good luck,
We're
sir.
asking for a short recess. We spoke with the state
Absolutely. For sure.
out of his office.
Maybe a couple days or however long you want. And
Sir.
yeah. All right. Good luck, sir.
Thank you.
Judge, can I call up the arraignment?
Hey, Nathan, can I do an arraignment real quick?
Well, I'm just gonna take a minute of your time.
Okay, come on. Great to see you, man. What's
Pleasure.
Happy Fridays?
Yes. Judge.
Morning, gentlemen.
So these are two U of H pre-law students.
Great.
All right. So Peter and Elijah, their class is getting a tour of the building. And when I was picking them downstairs, they had mentioned that they had seen you and they wanted to meet you.
We saw you on so many times on TikTok, and it's a great honor.
Yeah, I don't know who puts I don't put it on there, so I have no idea, but
You've gone viral, like I've seen so many times, and I'm amused, like, by the way you name it.
By the way, they have no idea who I am.
No, but we know who you are. So we were just wondering if we could just get a picture of you.
Let's skip that part.
I'm okay with it. Yeah, I'm okay.
I know
with
there's
it.
like,
Just let
I don't know
me
photography about, but
just do a couple things here and there, and then if you just give me a couple minutes, I'm happy to take a
All right,
picture.
Judge, I've got to actually run to another court. So if you don't mind, can I leave them in your jury box?
No, not in the jury box.
Okay.
Where?
The witness stand.
Oh, yeah, if you can hang out in the witness stand here.
Now can we call up the arraignment?
Sure.
All right. Page 13, Miss Morris, come on up, please.
Yes or no?
Judge, I thought she was one of the ones that had him with somebody. That was one.
Okay, not a problem. Coming up, Miss Morris. Good morning, ma'am. Ma'am, you are charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Thank you, Your Honor.
Shh.
On April 17th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a disturbance and made contact with the reportee, who stated the defendant had left the scene. While speaking to the reportee, the defendant drove up to the scene, and the law enforcement officer observed the defendant exit out of the driver's side of the vehicle and was the only person in the vehicle. The law enforcement
You can literally hear the panic starting when the defendant tries to speak and the judge cuts him off instantly. That's not the judge being rude. That's the judge trying to stop him from accidentally damaging his own case in real time. One sentence said emotionally in court can become evidence later. And notice how intense the warning gets about driving without an interlock? At this point, the judge is basically saying, if you ignore these conditions, jail is no longer a possibility. It's the expectation.
officer observed the defendant to have red, glossy eyes and slurred speech. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN. A 3 out of 4 was recorded on the one-legged stand. It states here that the other test was refused. The law enforcement officer found an open alcoholic beverage, mostly empty and cold to the touch, in the center cup holder, and several other unopened alcoholic beverages cold to the touch. The defendant refused to provide a specimen. Blood warrant was obtained and executed.
Did you say that there was an accident initially that brought them to the attention, or what?
Judge, it just says that the law enforcement officers were dispatched to a disturbance and the defendant drove back to the scene that she had left from.
My fiance.
Stop. Don't. You have the right to remain silent. Exercise that right.
There's no accident, Your Honor. It was just, they were called out to a disturbance. I believe it was a disturbance with. There's a disturbance under the weapon call, Your Honor. They drove up to the location and made contact with a complaining witness who stated that the defendant had left the location, and then while they were speaking to the complaining witness,
That's when she comes back.
that's when their defendant came back.
Okay. All right, Ms. Morris, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive at all. I'm now going to have you sign an affidavit with me today, promising you're not going to drive. I don't care what is going on in your life. You will be signing an affidavit with me today, promising you're not going to drive. Do you understand? Because this is a second offense, you will be required to obtain a portable interlock device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. I will also randomly test you for drugs. If I find that you're using, I will revoke your bond and put you in jail. No more PR bonds. Do you understand, ma'am? You're sending notice to DPS now that I'm placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have a guardian interlock. If you're caught driving a vehicle, it doesn't have an interlock on it, an officer in this state will know that you're required and they will arrest you and put you in jail. And you're in violation of these bond conditions. Do you understand? You have the ability to hire a lawyer, ma'am. We're going to give you time to hire a lawyer. So what I'm going to do is I'll have you go to Victoria, sign a reset. I'm going to first have you come up here, swear to us that you're not going to drive. You will then get with pretrial services for your bond conditions. And then after that, you'll be free to go. Do not use. Do you understand? Alcohol or illegal drugs. It's not going to go well.
I can't work.
I didn't say you couldn't work. I just said you. I'm ordering you not to drive.
They put an interlock in there already.
Okay. Right.